Welcome all. My name is Joo-Cheong Tham. I'm a member of the Center for Employment and Labor Relations Law and also a professor at this law school, and also one of the co-presenters. So I'll be presenting together with my collaborator and friend, Dr. Frances Flanagan from the Law School, University of Technology, Sydney. And this presentation really is sort of a synopsis of a chapter we've written for this broader collection called Climate Conscious Lawyering. It's edited by Julia Dem, Nicole Graham, and Zoe Ney, and it's really quite a really impressive, if not formidable, collection of chapters dealing a whole range of areas, from the priestly 11 subjects to elective subjects like bankruptcy law, and trying to look at through the lens of the climate crisis. It's an open source collection, so if you just Google climate conscious lawyering, you'll be able to access chapters in the book, including our chapter. So I thought I'll make a little plug for that, because it's been actually a massive and really quite admirable collection that Julia, Nicole, and Zoe have actually assembled. Okay, so how this is going to work is that Frances is going to do most of the work. She'll introduce, set the scene, and do the first half of the analysis, and then I'll do the second half, and then I think we'll have ample time for questions and discussion. So I'll pass it on to Frances.
Okay, great. All right. Thank you, Joo-Cheong. It's a real pleasure to be here at the Centre. I'm so grateful to be here. When Joo-Cheong suggested that we'd give a second version of this talk after the general Melbourne Law School talk, I was surprised that there would be an audience for a second version, but it seems as though I was wrong. So thank you so much for coming. Before I start, I'd also like to acknowledge that I'm very grateful to be here on the traditional lands of the Wurundjeri people of the Kulin Nation. So I acknowledge their traditional ownership. Okay, so our chapter, as Joo-Cheong says, really does follow the structure and thesis of the Climate Conscious Lawyering book, in the sense that it's animated by two kinds of central questions. One, got a lot of slides here. Okay. How has Australian labour law contributed to climate action or climate change? And how should Australian labour law contribute to climate change? I guess before we begin, implicit in our way of approaching these questions is a kind of understanding of the climate crisis that very much views it as something that is beyond a mere sort of problem of atmospheric emissions, if you like. It really views the idea of climate crisis as a crisis of eco-social ordering. That is, there is a kind of misalignment at play between the ways in which the kinds of human activity that we know are required for a genuinely sustainable society, something that values the reproduction of human and non-human life as well as production. There's a misalignment between those activities and the way they are valued, protected and rewarded under current conditions. So our chapter is structured as follows. We sort of begin with a kind of talk about the central role of labour law in the climate crisis, the contradictory logics of labour law in the climate crisis, how labour law is indifferent to climate action, and then this will be Joo-Cheong's part, talking about moving towards a climate conscious Australian labour law. So we begin with orientation of, I guess, matters that are extremely familiar to you all. That Australian labour law comprises of three core areas: the contract of employment, minimum standards, both legislative standards and awards, and collective bargaining, including industrial action. An adjunct to those are two areas of law: work health and safety law and equality and anti-discrimination law. Now, all of these areas of law bear upon two critically important forms of climate action. Firstly, climate adaptation, and that is the process of adjustment to climate change in order to moderate harm. It involves the creation, maintenance and repair of social and physical infrastructures. It spans blue, white, pink collar work, as well as work in informal and unpaid contexts. These also bear upon climate mitigation, which is the rapid and fair phasing out of employment in fossil fuel extractive industries. Mitigation involves reducing emissions in every industry and workplace. It involves establishing and maintaining renewable energy infrastructure at sufficient speed and scale. Now, sometimes these processes are referred to as just transition, That's a term with a kind of contested and flexible meaning. It's not one we lean on heavily in this chapter, and I'm happy to, I guess, speak about why perhaps in the questions, because it's kind of a big topic. Okay, so to really grasp labour law's role in the climate crisis, we need to situate its key principles in their historic context. So the two, I guess, that we're most familiar with are the principle that labour is not a commodity, originally articulated in those terms in the 1880s, and something, as we know, is enshrined as a first fundamental principle in the 1944 Declaration of Philadelphia for the ILO. The other idea is the notion that labour law's purpose is to be a source of countervailing power, to counteract inequality in the of bargaining power that is inherent in the employment relationship. We often associate that with Otto Kahn-Freund. So in giving effect to these ideas, labour law is serving two purposes at once. It is, on the one hand, an agent of social integration because it provides legally enforced conformity with collectively held values of social justice. And on the other hand, it is an enabler of capital accumulation. What we insist upon is the importance of understanding those two moves in a historic context where labour law was providing for the partial decommodification of labour, but in a context where nature was not decommodified at all. So what that means is that modern labour law effectively replicates and naturalises a kind of disconnection between land and labour. And as a result, the positioning, labour law effectively positions the environment as outside its scope. It conceptualises as a kind of neutral and taken for granted backdrop to the real drama of industrial relations and the employment relationship. So if we speed forward now to the 21st century and we look at 21st century labour law and how it carries this conceptual imprint, we say it does so in the following ways. It typically does not have environmental objectives. It severely restricts the pursuit of environmental objectives in collective bargaining and industrial action. It doesn't systematically provide for climate action, and it's premised upon continuous economic growth. Now, with the partial exception of work health and safety laws, and I'll return to those a little bit later, Australian labour law doesn't have environmental objectives. Now, this is apparent if you look at the objectives of the Fair Work Act. There are 10 elements that are provided there, and these are all very important social and economic objectives. However, none of them situate the economy and society within an ecological context. This is important. It's important because we've just learned from the ICJ advisory opinion on the obligations of states in response to climate change that all states have a duty now to take mitigation measures in line with the best available science, to regulate non-state actors accordingly, and effectively to subordinate their economic activity to those duties. So that absence within the objectives of the Fair Work Act flows then through to the modern awards objective, the minimum wages objective, and the objects of the enterprise bargaining provisions. Now, just to be clear, the absence of any environmental objectives in the Act doesn't mean that employers do not engage in environmental action. They are, of course, subject to regulation from environmental laws that regulate a range of matters from, pollution, site contamination, noise, water and waste. It also doesn't mean that workers do not feel a sense of responsibility for the contribution of their labour to environmental issues. And we've got many examples of unions and workers expressing that sense of responsibility from the 1970s to the present. So many of you will be familiar with the green bans movements that saved so many buildings and spaces here in Melbourne. Similarly, the ACTU passing resolutions for a moratorium of uranium mining, new uranium mining and export for nuclear purposes. All of this idea that in light of the existential threats to which the purpose of labour may be put, it is acceptable and important that there's a sense of social responsibility exercised collectively by workers. So, and so I should also say that this is not like a 1970s phenomenon only. Some of you might be familiar with the occupation in a factory of the GKN factory in Florence, where we've seen workers refuse to participate in a factory that was making luxury cars and instead wanted to repurpose those functions to make cargo bikes and solar panels. And they've actually been successful in then getting ownership of the factory after 3 years of strikes and doing that. So, despite these solidarities and these sensibilities that mean that environmentalism is enacted and thought about on both sides, the Present Fair Work Act means that environmental policies are enacted within a managerialist rather than a contested setting. So that means that employees are welcome to be involved in environmental decision making, but on a consultative basis and on matters that fall within the common interests of employers and employees. So that might be things like waste management or transport policies. It doesn't afford a legal entitlement to engage in conflict and take collective action over sustainability issues in a more fundamental sense. And just to say that that observation is supported by empirical work that's been done into enterprise bargaining agreements that really does seem to confirm the centrality of employer prerogative in environmental agreement making. And this is research, it's a little bit dated now, it was done around 2016 by Ray Markey and Joe McIver. And what they found is that environmental clauses in EBAs are rare at the time, around 7% of all enterprise agreements in the period. And they were as likely to be driven by management as by unions. So many of the clauses contain very general commitments to environmental improvement, but 40% of them place the onus of environmental protection on employees, and 8% of them put environmental issues as a disciplinary measure that included summary dismissal. So we're looking at something very much a sort of managerial prerogative framing for environmental issues under the current Fair Work Act. So the Fair Work Act's framework for pursuing environmental objectives is a highly restricted one, and that is for 3 reasons. One, the subject matter for bargaining is very narrow. And of course, we can trace this back to the early 20th century in 1904 when the High Court interpreted the term industrial matters to mean only matters directly affecting work done or the mutual rights and privileges of employees and employers. When the Fair Work Act was amended or brought in, that jurisprudence flowed through to limit the content of enterprise agreements to permitted matters. So things like job security, working hours, leave entitlements. Now, just to be clear, all these things are extremely important for a climate change adaptive labour law system. So I'm not saying they're not important at all. But what it does mean at the same time is that matters that are not within the employment relationship, such as energy efficiency, planning for net zero, corporate accountability for impacts or investment decisions, environmental harms created by the firm, these are not permitted matters and they have no effect. As well as that, we see restrictions at the level of bargaining that stem from the structural bias in the Fair Work Act towards bargaining at the enterprise level. And while, of course, there have been amendments that now introduce single interest bargaining streams and supported bargaining streams, for the purposes of this conversation, they don't bear upon these questions. So what that means is that whatever green bargaining occurs is channeled into what might be perhaps the least effective level of bargaining, the place where the tensions between job security and environmental objectives are probably the most difficult to reconcile. It's a kind of myopic frame that means it's not possible to allow for negotiation at the level of industry or region or supply chains. And that is the level at which some of the most inspiring examples of transformative change in this space have been. If we think about things like the IUF's campaign to end the exploitation and extractive practices in the entire food system, looking at the way in which exploitation is addressed to the human and non-human world at every level, from land use change to animal feed to processing to retailing, agricultural workers, hospitality workers. All of this involves a gaze that is so much broader than the enterprise level gaze. And then finally, there is a restriction on the ability to take industrial action, which is similarly limited in scope and scale. That is because the immunity for protected industrial action is confined to permitted matters. And of course, the consequences of attempting to do this are very punitive. Workers and unions will be exposed to punitive common law actions. The same generally applies to green bargaining with multiple employers. And the Fair Work Commission is obliged to issue cease and desist orders for industrial action that is not protected. Now, Australia's Fair Work Act generally is already criticised by the ILO's Committee on Freedom of Association and the Committee of Experts for breach of the ILO Conventions on Freedom of Association and Collective Bargaining, 87 and 98. But we say that the climate context gives these criticisms new force and significance. Okay, so I said something before about work health and safety laws, and I just want to emphasise what a crucial and important role that they play in this. Work health and safety has a very important promise and role in climate change societies because it is premised on this responsibility of employers to assess risks and protect workers from hazards regardless of their employment status. Now, in a place and a land which is increasingly going to be exposed to high heat, polluted air, increased ultraviolet radiation, obviously this sense of responsibility towards workers is extremely important. The problem is several. One, these obligations are not being realised in practice, and empirical work by the ILO and here in Australia has very much made that clear. The other is a more sort of structural and conceptual limitation, which is that the law is confined in its operation to the boundaries of the business or undertaking, or any place where the worker goes or is likely to be while at work. And they only demand action which is reasonably practicable. So what we say is that while this is important, it doesn't provide a collective basis for a systemic response to unsafe work due to environmental instability, particularly when those impacts are generalised, chronic, involve multiple kinds of infrastructure breakdown, require the wholesale relocation of people from one to another. I would say, as an offhand thing, there's also interesting developments in Spain to do with the awarding of 4 days paid climate leave when the temperature reaches a certain level as determined by the Bureau of Meteorology. I think that's a very interesting idea because it means that it's almost just like the climate itself can go on strike, if you know what I mean, like there's something external to human agency that says that work must cease. So I'm not saying that there aren't really interesting ways of thinking about how work health and safety can be political in a more systemic way, but in terms of the current Fair Work Act, it's a more confined role. Okay, and sorry, the other point is that labour law offers limited scope for climate planning. So we'll return to that a little bit later when we talk about the Net Zero Economy Authority. But essentially, the law provides no basis for planning before the closures have been announced. Okay, and finally, perhaps it goes without saying that the Act is underwritten by a premise of continuous economic growth. This is reflected in the object of the Fair Work Act, which speaks about providing a balanced framework for cooperative and productive workplace relations that promotes national economic prosperity and social inclusion for all Australians by providing workplace relation laws that promote productivity and economic growth for Australia's future economic prosperity. And these are similar to the objects of the Future Made in Australia Act. Now, these goals really are not aligned with the imperative for a fundamental reconfiguration of the economy to a different kind of purpose. And we can note that they're also being pursued at the same time as Australia continues to develop and approve new fossil fuel resources for export, including an increase in the production of coal up to 2030 and approvals for gas extraction in the Northwest Shelf up to the 2070s. But also accompanied by actions by the Australian government to develop international law, to oppose developments in international law that recognise the responsibility of high-emitting states like Australia to prevent transboundary harms that occur from greenhouse gas emissions. So I guess what we want to say is that labour law as it's currently configured doesn't provide a foundation for contesting this general direction of travel. Okay, I'm now going to hand over to Joo-Cheong.
No worries. Thanks so much, Frances. So this is really the sort of second substantive part of our chapter, and really dealing with the second question, that central question that we're asked to address is really how ought the climate crisis shape labour law. And really, what we seek to argue for is really from a climate indifferent labor law to a climate conscious labor law. Now, of course, the task is immense, yeah, in terms of making that shift. So we've really, what we do in this particular part are really sketch out 4 pathways that we consider to be vital in that shift from a climate indifferent to a climate conscious labor law. So the first pathway is really moving from the othering of nature, where nature and the environment are basically naturalized in the background and brought into the foreground, yes? And brought in the foreground in terms of the express objects of the Fair Work Act. And in that chapter, we just give various ways that this can be done. We could integrate the objects of the Climate Change Act in terms of addressing climate change based on the best available scientific evidence and have that also replicated in the Fair Work Act. We could, referring to, what Frances said with the International Court of Justice, holding about the duty of nations to deal with climate change, also not just refer to international obligations that deal with labor, strictly speaking, the ILO conventions, but also to deal with the duties in terms of the climate crisis. And we could expand the understanding of well-being, which is a concept that finds itself Section 3 of the Fair Work Act, and to spell out that it doesn't just pertain to present generations, but also the well-being of future generations. And I think alongside these various inclusion, these various objectives, I think what we spell out in the chapter is the importance of also foregrounding planning. Yeah. So Anthony Giddens has made a very powerful argument that in terms of in this ecological crisis, the state becomes all the more important, but we must think carefully how the state is configured, what kind of state we want, particularly if we want a democratic state. And what is argued for is a planning state. And we do in fact see elements of this reflected in various ways. The Net Zero Economic Authority Act talks about energy industry jobs plan, even though perhaps the substantive requirements fall a bit short about that. The UN High-Level Expert Group on Net Zero Emissions Commitments on non-state entities have called for businesses to adopt net zero transition plans. Yeah, so this becomes important, I think, in a few slides ago in terms of Frances' presentation, that we're dealing with a crisis that the ILO Research Department is characterized as the impact of which is akin to the Industrial Revolution. Now, it's akin to Industrial Revolution, perhaps, but there's one difference, and I think it was an important difference that my colleague Jackie Peel brought out in the seminar we gave to the faculty, that in fact, the time periods might be much more compressed than the Industrial Revolution that went over a century or so. We might be talking about changes of that scale and depth, but over a span of decades rather than over a span of a century. Yeah? So planning becomes all the more important. Now, the other way we point out that environmental objectives could be integrated into labor law is really expanding the scope of the Net Zero Economic Authority. So I think there's clearly innovative features into the Net Zero Economic Authority Act, but one shortcoming that its scope is quite narrow. And as Frances pointed out, its scope is essentially dealing with gas-fired and coal-fired power plants that basically the decisions be made to close them. Yeah. Whereas if we're thinking about a transition of the scale and depth of industrial revolution, it clearly goes beyond those very specific situations. So we need to think about how to sort of plan and integrate environmental objectives in a much broader and deeper scale. I mean, what we also argue in all of this is that I think the importance of actually recognizing distinctive role of indigenous workers. I think this has been recognized not just by the International Labour Organization, but also in terms of the various statutes, the 2 key statutes in this area, the Net Zero Economic Authority Act and the Future Made in Australia Act. Green bargaining, I think this requires quite profound changes to how bargaining actually occurs under the strictures of the Fair Work Act, both in terms of subject matter and the level. Yes? So subject matter and what you see up there is really an opinion, a European Union opinion, where saying that green collective bargaining should extend to those 4 areas. And you can see that for those familiar with Section 172 of the Fair Work Act, permitted matters, that particularly impact on companies' activities and environment goes way beyond, yeah, what can be bargained for under the Fair Work Act. Yes? And I think the other point to be made is, of course, not just about scope, but also a level. I think as Frances pointed out, that I think the structural bias towards bargaining enterprise level will mean that these kind of matters are dealt with the level at which the trade-offs are most acute, between the often sort of jobs versus environment trade-offs, and can be least effectively dealt with. So we need to be thinking about, at the very least, allowing bargaining on these matters at the industry level, supply chains, or perhaps even at the national level. Now, I think it's important to acknowledge and be honest that even if green bargaining is permitted, it doesn't mean it will eventuate. So the ILO research has documented that even in countries where green bargaining is permitted, you in fact find it's not very frequent to find so-called green clauses. And I think the reasons are not difficult to understand. I think often bargaining centers along, across the world, on certain core topics, wages, job security, working hours, and of course, things like job classifications and so on and so forth. Now, all those things also are still central in terms of green bargaining. If we think about the job restructuring and industry restructuring is going to occur in this transition, then of course, job security is crucial, working hours also becomes important if we're thinking about moving to a different economic model and so on and so forth. But clearly, those topics do not exhaust the full area in terms of what's required in terms of green bargaining, whether it be the commitments of the company to net zero, energy efficiency measures, and so on and so forth. So what we suggest that perhaps there needs to be, what we have under the Australian Fair Work Act is firstly, an approach towards collective bargaining that is restrictive, and on the other hand, kind of laissez-faire or permissive. So within the strictures of the Act, the parties basically, whatever the bargain for and so on and so forth is left to the parties. But perhaps the urgency of this crisis calls for a kind of stronger approach that still respects autonomy of the bargaining parties, but is much more facilitative or encouraging, promotional. And I think this will be in line with ILO Convention 98. It talks about promotion of voluntary collective bargaining. And there are measures in Spain and France, for example, where it's mandated for parties to bargain on certain topics. The outcomes are not mandated, but the fact that they have to bargain is mandated. And I think those measures, are worthy of closer consideration. Now, there's a lot to be said about the third pathway, and it's really about normative bearings, if you like. I think the principle of democracy and a sort of a broad principle of democracy in labor law is well established, And it's a broad principle because it doesn't just speak about democracy as effected through elections or through government, but it's democracy at the workplace. And to see both of them intertwined. And we see that, for example, in the fourth principle of the Declaration of Philadelphia, where it talks about, government, employers, and representatives of workers coming together in joint decision-making, and so on and so forth. What we argue in this chapter is that should be brought together in the climate crisis. What it calls for is sort of a integration of that principle of democracy, the principle of solidarity. And solidarity is, of course, a very familiar principle in the labor law context, particularly in terms of labor solidarity and solidarity that's institutionalized, for example, through social protection measures and so on and so forth, through pooling a risk and so on and so forth. And what we say, in fact, because what we have in the climate crisis is that strong calls for solidarity within generations, between generations, and also most challenging and most profoundly challenging with nature. I think bringing those together, and I know that task is immense and the task is formidable, but I think in terms of normatively orientating ourselves in this existential crisis. And thinking about it, both not just in terms of the workplace, but also in terms of relationship between workers and the organizations and the state. Happy to take questions and say much more about this, but conscious of time, but I'll move on to the last pathway. Now, the first statement you have there is from the Secretariat of the United Nations Framework Convention on Climate Change. So a growth-oriented economy may not be compatible with a climate-safe economy. In fact, it's not too difficult to understand. So the Stockholm Resilience Center has come up with a very important notion of planetary boundaries. Yeah? So there are 9 planetary boundaries, of which if the boundaries are crossed, that you basically run the risk of tipping points, yeah, okay, of basically threats emerging that basically pose existential threat to the biosphere that actually houses humanity. Yes? Okay. So implicit in, of course not implicit, I mean, I think what's clear with this idea of planetary boundaries is that the ecological system is a closed system. Yes? However, if we treat the premise of continuous economic growth as a sacred premise, yeah, and continuous economic growth is of course about exponential growth, yes, then we're treating the economy as an open system that's capable of infinite growth, yes. Then at some point, and in fact the point has already been crossed, that closed system will collide with an open system, sorry, or what's treated as open system will collide with the closed system. So currently, according to the Stockholm Resilience Center, 7 planetary boundaries have been crossed, including the one dealing with greenhouse gas emissions. Yes? And you see the quote here by Pope Francis, which puts it in a much more plainer and perhaps more honest way, that this idea of infinite unlimited growth, which is basically is implied when we hold on to continuous economic growth as basically a touchstone, yeah, or maybe even the key touchstone of public policy, is based on the lie, yeah? There's an infinite supply of Earth's goods and leads to the planet being squeezed dry at every limit. So what we call for is clearly an exploration of post-growth, yeah? Post-growth futures for Australia. And I think there's a growing body of scholarship talking about prosperity without growth. So it's not giving up of the idea of prosperity, but perhaps re-envisaging it. For example, Kate Raworth is in her book, Donut Economics, talks about prosperity being based on a donut. So in a donut is basically the minimum, the kind of minimum social foundation that meets the needs of humanity, education, health, jobs, so on and so forth. Then the outer donut is ecological ceiling, or the planetary boundaries. And basically having an understanding of prosperity that allows humanity to basically live in that sweet spot between the inner and outer layer of the donut. This is a formidable and confronting challenge, yes? Yeah? And here we must recognize that exploring post-growth scenarios is also about exploring post-capitalist scenarios, yes? All right? So what you see here by David Harvey, a Marxist geographer, is that says that, okay, when we think about capitalism, and Wolfgang Streeck talks about capitalism as being a capitalist society being a progressive society, in a sense that it depends on constant accumulation and growth. Yes, in that sense, in that narrow sense of economic growth. Yes, so if we're talking about perhaps even zero growth economy or degrowth economies, yeah, we're talking about basic scenarios where capitalism, okay, does not exist in a way that we understand it to be, yeah? As Harvey says, okay, a zero growth capitalist economy is a logical and exclusionary contradiction. So where we end is that the climate crisis is also a crisis for labor law. And here we draw upon Jared Diamond's work in terms of crisis to think about crisis through its Janus phase, yes? Now, of course, there's a phase of crisis that we often focus on. It's a part that's about danger. And what Diamond does in his introduction is basically he foregrounds the Mandarin word for crisis, Wei Qi, which has 2 characters. The first one being the part we focus on, danger, but the other part being of opportunity. Yeah? And what we would like to see is really that opportunity taken, yeah, moving from a climate different to a climate conscious labor law, and perhaps with the orientation that Nicholas Polancis called revolutionary reformism, where basically we have basically short-term measures that we can take, for example, integrating environmental objectives in the Fair Work Act, but also basically embedded within a broader outlook that thinks about a radically different economic model that is post-growth and post-capitalist.